Assalamualaikum and hi. We are from Group 7. We'll present to you guys about Whistleblower Protection Act 2010. Now, let me introduce you guys with my group members, which is Daniel AMIRUL AIMAN, NURUL BALQIS, Siti Syazwani, and me, AIMI SYAIRAH. Whistleblower can be defined as a person, often an employee who reveals information about activity within a private or public organization that is deemed illegal, immoral, illicit, unsafe, or fraudulent. Whistleblowers can use a variety of internal or external channels to communicate information or allegations. Over 83% of whistleblowers report internally to a supervisor, human resources, compliance, or a neutral third party within the company, hoping that the company will address and correct the issues. A whistleblower can also bring allegations to light by communicating with external entities such as the media, government, or law enforcement. Whistleblowing can occur in either the private sector or the public sector. Whistleblowers do not always achieve their aims. For either claims to be credible and successful, they must have compelling evidence to their claims that the governments or regulating body can use or investigate to prove such claims and hold corrupt companies or government agencies to account.
Assalamualaikum warahmatullahi wabarakatuh. My name is Danial AMIRUL AIMAN bin AHMAD ZAMURI, and now I will continue our presentation today with the Whistleblower Protection Act 2010. The Whistleblower Protection Act 2010 was enacted by the Parliament of Malaysia on 15 December 2010 and has been in use since then. As part of its purpose of preventing corruption and other wrongdoings, this law encourages and facilitates the disclosure of improper conduct, whether it be in the public or private sector. Further, this act provides protection against adverse action for the people making those disclosures, provide for investigation of the matters disclosed, and provides other related provisions. The terms public body includes the Government of Malaysia, the Government of a State, any local authority or statutory authority, any department of service under the Government of Malaysia, Government of the State, or local authority, and any company or subsidiary company they control or have significant interest in. Any office or organisation that is not a public organisation is considered a private organisation. So next, the whistleblowing. Generally, whistleblowing refers to any disclosure made by members of an organisation, either current or former, regarding any illegal, immoral, or illegitimate practices under the supervision of the employer. When it comes to whistleblowing about an organization's wrongdoings, it can be done internally or externally with the purpose of rectifying the corporate malpractice and wrongdoings. An internal whistleblower and external whistleblower are both types of whistleblowing. When improper conduct is reported to outside parties, such as regulatory agencies, it considers external whistleblowing. In contrast, an internal whistleblower is someone who reports improper conduct within a company only. Whistleblowing, however, is only allowed through enforcement agencies in accordance with the Whistleblower Protection Act 2010. So, what is the process of whistleblowing? Firstly, a whistleblower has the right to disclose, report, and complain about any improper conduct to any enforcement agency that has been granted the authority and rights to investigate and enforce the inappropriate conduct. As soon as the enforcement agency receives the complaint, it shall begin the investigation process. Upon completion of the investigation, the enforcement agency shall prepare a report for submission to the public prosecutor and, whenever possible, the relevant authorities. Whenever the public prosecutor takes any actions, the enforcement agency should be notified so that the whistleblower is kept updated as to what the enforcement agency has done so far. A complaint may be reported to the Minister in the Prime Minister Department for further investigation if the enforcement agency found that the public prosecutor hadn't taken adequate measure to investigate the complaint. According to Section 15, Subsection 1 of Whistleblower Protection Act 2010, if the whistleblower experience any detrimental or retaliatory action, they are entitled to compensation or remedies from the enforcement agency. Under this section, it has been provided that the whistleblower has two options. If he suffers from any detrimental action, he can make a request to the enforcement agencies to seek remedies, for they could seek the remedies of their own. The court's power in granting the remedies to the whistleblower is very broad, and they can make any order such as an order for compensation, cost interest or any other relief that the court deems fit. Under Section 18, Subsection 2 of Whistleblower Protection Act 2010, it has listed out the type of orders that court can make. It includes an order to permit the whistleblower to return to his work and the right to order for the restatement of the whistleblower.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Syazwani binti JASNI. Will explain about the suggestion for improvement of Whistleblowing Protection Act 2010. Many countries have enacted legislation to protect whistleblowers, exemplifies the importance of whistleblowing in promoting good governance within both public and private institutions. Malaysia's poor reputation on corruption took a serious hit with the 2015 scandal concerning the One Malaysia Development Board, which also known as 1MDB, and things have not improved much since then. If the Malaysian government is serious about cleaning up the country and improving its international reputation, it needs to do more than just hold accountable those responsible for 1MDB and other scandals. Looking forward, Malaysia must also improve its legal framework for the detection and prevention of corruption. In this regard, as leading anti-corruption advocacy organization have emphasized, stronger whistleblower protection is essential. Most forms of corruption are hard for outsiders to detect, and those with first-hand knowledge of possible of wrongdoing will be reluctant to report what they know unless they have, at a bare minimum, sufficient protection against retaliation. Malaysia also showed its commitment in eradicating corporate fraud, corruption and misbehavior through the enactment of WPA 2010. However, until now, whistleblowers have yet to be an effective tool in fighting corruption. Therefore, to make whistleblowing as an effective tool in the fighting corruption, there are some recommendations should be considered. The first improvement that they can do is first, provide more protection to whistleblowers. In certain scenarios, whistleblowers tend to disclose the misconduct of an organization to a body other than the enforcement agency, such as the news media or other third party, since they lack of confidence in authorities in charge of handling whistleblower cases. Moreover, they also have this fear whereby their disclosure will not be investigated truly and properly or even handled seriously. Thus, the WPA 2010 should be amended by permitting disclosures by whistleblowers to a non-enforcement agency while maintaining their protection, while also avoiding the risk of being subjected to fine or imprisonment. The WPA 2010 must be altered in order to protect the whistleblower as opposed to restricting them from disclosing potential misconduct. If the information being provided by the whistleblower is related to a corruption action being carried out by a public official or even within a government institution itself, then the Act should not ring-fence the information. The WPA 2010 in Malaysia should make amendment to the Act to allow more independent statutory bodies to provide protection for whistleblowers in a similar manner as in Australia and the United Kingdom. Next is develop and create a more comprehensive whistleblowing mechanism. The first step is to create specialized units among the enforcement agency to oversee disclosure methods. Whistleblowing in general may be a terrifying and frightening experience as it comes with many risks and threats. Most of the time, whistleblowers feel that they are not feeling secure upon making disclosures involving misconduct or corrupt acts. Whistleblowers who possess sensitive information should be informed early on that a dedicated and secure channel is available to communicate with enforcement agency either by using emails, walk-in or via phone calls. Enforcement agency need to hire trained personnel who are specialized in whistleblower disclosures that will allow the most suitable reception and handling of sensitive disclosures, as well as to increase the confidence of the public in making the disclosures to such agency in the first place. And last but not least is establishing the grounds for more independence in the Act. The WPA 2010 needs to protect whistleblowers and also encourage them to disclose sensitive information that may include elements of corruption. It is imperative that the Act must be amended to be independent and free of involvement from potentially corrupted government parties. This means that the ministerial oversight of the Act must be removed and instead appoint an independent authority in his place to oversee the Act to provide better protection mechanism to the WPA 2010.
Now, I will talk about the advantages and disadvantages of whistleblowing. The first advantages is that we can expose unethical behavior. The whistleblower serves a vital function in governments and business. When corporations and government agencies step over legal and ethical lines, whistleblowers can make these practices public knowledge, which can lead to violators being held accountable. The added scrutiny that comes with criminal investigations, civil lawsuits, and media attention can influence the behavior of similar organizations. Companies and government offices that engage in similar misconduct may have previously believed that they could get away with their bad behavior, but the ripple effect of the whistleblower's efforts can bring about reforms. The second advantages of whistleblowing is legal protection. The federal government's Whistleblower Protection Program protects employees who report violations of various workplace safety, environmental, financial reform, and security laws. The program protects from retaliation workers who blow the whistle on their employers' behavior. Retaliatory action can include dismissal, demotion, denial of benefits, and reduction of working hours. Companies found to be in violation of the whistleblower protection laws can face fines, suspension of government contract, and civil lawsuits. The last one of advantages of whistleblowing is to build trust. The process of whistleblowing includes early warning, brand enhancing, and finally the compliance to law. Marinating the whistleblowing activity demonstrates that the company prefers to maintain high ethical standards, which starts creating trust in the employees as well as the shareholders of the organization that the management will never be unethical and work in future. Due to this policy, the employees are dedicated towards their roles and responsibilities, and the shareholders feel that they will get a great and true possible return from the organizations. The organizations even have the options to comply with the anti-corruption laws and address stronger legal protection of whistleblowers. It is important that the irregularity and unethical working can be brought into the limelights of the management so that they can justify every step taken by them to enhance the working environment of the organization. Next is personal complications. Although whistleblowers may understand that their revelations serve the greater good, they also often endure personal problems from their actions. Media outlets in search of a story will delve deeper into whistleblowers' personal lives. Legal complications from criminal investigations and civil lawsuits against the company might require them to hire attorneys to defend themselves. They may also receive threats of retaliation from former supervisors and co-workers. All of this added stress and can cause severe health problems and fractures in their relationships. Now, we will move on to the disadvantages of whistleblowing. Whistleblowing can diminish career prospects. The attention that a whistleblower case brings, both to the employees and the company, can have a downside. Media interviews, legal testimony, and government investigations can affect the whistleblower's career prospects. While the outside world may view whistleblowers as heroes for revealing corrupt behavior, industry insiders and hiring managers may see them as disloyal or indiscreet for not keeping company secrets and industry practices under wraps. The media attention may lead to the whistleblower being blacklisted in the industry. Lastly, the disadvantages of whistleblowing is to manage proof. Although Whistleblowing Act mandates each organization to implement whistleblowing laws, but it is responsibility of whistleblower to prove charges against the accused. So, whistleblowers should have all the data, which should convince top management that all the facts mentioned are 100% true. Otherwise, charges will be ignored and whistleblower will be at risk of losing trust and other consequences too.
Next, I will explain about the whistleblowers and internal audit. It is independence from management, means that it has the potential to be directly involved in whistleblowing arrangement, whether in a triage role or as an investigator. Alternatively, internal audit's role around improving control makes it ideally placed to provide assurance to the board on the effectiveness of the whistleblowing process. So the first one is internal auditors acting in a triage role. Established and trusted whistleblowing hotlines are likely to experience an increasing number of calls and tip-off. In these circumstances, it is important to have process for evaluating and prioritizing reports. Medical triage program provide a good model. Used by modern emergency department, paramedics and first responders, triage is the process of determining the priority of patients' treatment based on the severity of their condition. Internal auditors should take a risk-based approach with the following recommendation, which are: the initial capture of the tip-off is crucial, which all the reports should be acknowledged and responded to as quickly as possible. The second one is prioritize action on the reports according to the risks. While allegations of fraud and corruption are almost always serious, tip-off concerning health and safety or environmental breach may be critical depending on the risk profile of their organization. Delegate report that reflect misunderstanding, personal grievance, or minor error to a support group such as HR, which can handle them efficiently. Internal auditor as investigator. It is crucial for the credibility of the whistleblowing program that all disclosures are responded to quickly and are properly investigated. Internal auditor often perform investigation, especially those involving fraud. The key recommendation for internal auditors are commit to investigating all matters fully, fairly, quickly, and confidentially. Make recommendations for further action. Maintain a feedback loop to whistleblowers where their identity is known. The whistleblower should be kept informed of progress and outcomes, not ignore the following interview. It is very crucial that internal audit is properly resourced to carry out this work in terms of staffing and skills. For example, investigators require training in the rules of evidence and those conducting interviews, especially those under conditions of stress. The board has an important role to play here. It must ensure that internal audit's main function and wider assurance role are not compromised by its direct involvement in the whistleblowing process.
Assalamualaikum, my name is NURUL. I'm BALQIS binti ISHAK. Let's move to cases related to whistleblowing. I will explain two cases related, which the defendants are Genova Diagnostics Incorporation and Logan Labs. Firstly, Genova Diagnostics Incorporation, a clinical laboratory services company based in Asheville, North Carolina, has agreed to pay up to approximately $43 million to resolve allegations that it violated the False Claims Act, including claims that it billed for medically unnecessary lab tasks. The settlement resolves allegations that Genova first improperly submitted claims to Medicare, TRICARE, and the Federal Employee Health Program for its immunoglobulin G allergen, Nutrivol, and GI effects. Lab test profiles because the tests were not medically necessary. Second, engage in improper billing techniques. And third, paid compensation to 3 phlebotomy vendors that violated the physician self-referral prohibition, commonly known as the Stark Law. The Stark Law is intended to ensure that physician referrals are determined by the medical needs of patients and not the financial interests of physicians. Under settlement, Genova has agreed to pay approximately $17 million through the surrender of claim funds held in suspension by Medicare and TRICARE, plus up to an additional $26 million if certain financial contingencies occur within the next 5 years, for a total potential payment of up to $43 million. Second case is Logan Labs, a reference laboratory in Tampa, Florida. Tampa Pain Relief Centers Incorporation, Tampa Pain, a pain clinic also based in Tampa, Florida, and two of their former executives, Michael T. Dahl and Christopher Oostake. Collectively, defendants have agreed to pay a total of $41 million to resolve alleged violations of the False Claims Act for billing Medicare, Medicaid, TRICARE, and other federal health care programs for medically unnecessary urine drug tests (UDT). The government alleged that defendants knowingly submitted or caused the submission of false claims to federal healthcare programs for presumption and definitive UDT in circumstances where such testing was not medically reasonable or necessary. Presumptive UDT are tests that screen for the presence of drugs, and definitive UDT are tests that identify the amounts of those drugs in a patient's systems. In conclusion, the Whistleblower Protection Act 2010 was enacted to encourage and facilitate disclosure of improper conduct in both the public and private sectors. There are three limbs of whistleblower protection under the WPA: protection of confidential information, immunity from civil and criminal action, and protection from detrimental action. Among the grounds are that the whistleblower has participated in the improper conduct, disclosed, willfully disclosed information that they knew or believed to be false, and disclosed improper conduct that principally involves the questioning of the merits of a government policy. That's all from us. Thank you.